Welcome once again to Lehto's Law. Here's Steve Lehto.
We've talked on this channel before about the concept of a buffer law. That is a law that says you must stay a certain distance from police officers as they're doing their job. And if you don't, you can get in trouble for it. And some states have passed these laws, some have not yet. Some courts have upheld these laws, some courts have struck them down. There's a lot of turmoil in this field. And a case came down just a couple days ago that is huge because the court actually says that both sides missed the point, and the statute as it is written is good. However, the people who wrote the statute may need to rewrite it because of what the Court of Appeals did here. So this is from the Seventh Circuit U.S. Court of Appeals, case called Nicodemus versus the City of South Bend and the state of Indiana, because it's a state law we're talking about. And I'm going to refer to the man in the story as either the plaintiff or just the man in the story because it's easier for me to do it that way. But Indiana has a buffer law, making it a crime for a person to knowingly or intentionally approach an officer who is lawfully engaged in the execution of the law enforcement officer's duties after the law enforcement officer has ordered the person to stop approaching. Now, here's the key. I'm going to tell you right now what the punchline of the entire video is. The word approaching is what this court focuses on. And approaching is different than being someplace. Approaching indicates movement. So, seeking declaratory and injunctive relief, the man in the story, a citizen journalist, challenged the law as facially unconstitutional. He argues that it violates his First Amendment right to record the police in public spaces, and after consolidating the motion with a trial on the merits, the district court found Indiana's buffer law to be constitutional because it only had an incidental effect on the public's First Amendment right to record and scrutinize police activity. The district court denied the man's injunction request and entered final judgment for the defendants. For the reasons below, we affirm. And so the court points out that there was, in fact, a bench trial on the case. So the facts aren't really in dispute here. The man in the story is a citizen journalist from South Bend who's got a YouTube channel that has over 23,000 subscribers, and he records police activity in and around South Bend. So after midnight on July 20th of 2023, there was an incident in downtown South Bend at the intersection of North Brookfield Street and Lincoln Way West. The man hurried to the scene. When he got there, police were at one corner of the intersection marking evidence on the ground. 6 squad cars were present, with some blocking parts of the road. The man positioned himself on the sidewalk at the northeast corner of the intersection, joining a group of onlookers, and began live streaming. Shortly after, an officer walked up to the group and told them to move back, invoking the buffer law. He counted off 25 feet from the west side of the street where a squad car was parked and told the man and the others to move behind the imaginary 25-foot buffer line. The man was already across the street from the squad car, so he only had to move back a few feet. He continued recording while conversing with and criticizing the officers. Then came a disturbance on the north side of Lincoln Way past the intersection. So the man with the camera could not see what was happening from the vantage point, but chose to stay put instead of seeking an alternative angle. He and another videographer yelled at the police, asserting their right to record. In response, an officer approached the group, explaining that the area was a crime scene and invoking the buffer law. The officer told the group to move back another 25 feet. And the man protested that he had already been moved, but complied after being threatened with arrest. And this is something we talked about, is that if the zone is defined as distance from an officer, if the officer approaches you, you got to keep moving back. And they could back you up as long as they wanted to, right? Well, that's not what it actually says, though. The man claims that he sometimes needs to get closer than 25 feet to effectively record or live stream police activity, but that he does not disrupt or interfere with police work when he does. If he's more than 25 feet away, it can be difficult for him to see and hear what is happening and to capture police activity with his recording device. So, on August 8th of 2023, the man sued the city of South Bend, Indiana, saying that the law was a violation of his First Amendment rights, and also sought a preliminary injunction. And the court said, how about this? Let's just have a trial because it doesn't sound that complicated. The state of Indiana also intervened to defend the law. And after the trial, the district court determined that Indiana's buffer law was not facially unconstitutional. Specifically, the court held that the law did not violate the First Amendment because it had many permissible public safety justifications and posed only an incidental burden on a person's right to record. The district court entered judgment for the defendants, and now this man appeals. So the man argues that the buffer law violates the First Amendment because it gives unbridled discretion to law enforcement officers to determine when people may engage in protected activities on public sidewalks and in the street. In the alternative, he argues that the buffer law violates the constitutional requirement that the regulation of expressive conduct in a public forum be narrowly tailored and leave open ample alternative channels of communication. So the court here says, look, we're going to review the case, and here's the law for the standard of review. But before we can analyze the constitutionality of the buffer law, we first need to understand what it does and does not provide. And this is the key. The district court found the law prohibits a person from knowingly or intentionally approaching an officer within 25 feet after being ordered not to approach. We tend to agree. So the court's going to say, look, the lower court got it right, but it looks like pretty much everybody kind of missed the nuance of what's going on here. The parties argue as though the buffer law, once invoked, allows an officer to move anyone who happens to be within 25 feet of him back to a point outside the radius of 25 feet. We reject this apparently shared premise. So the court's saying, look, everybody agreed on what they're arguing about, but we actually think that they got the argument wrong. When interpreting a statute, Indiana courts begin with a text. If the text is clear and unambiguous, courts simply apply its plain and ordinary meaning. Indiana's unlawful encroachment on an investigation, referenced here as the buffer law, took effect on July 2nd, 2023. Here's the statute in its entirety, verbatim. A person who knowingly or intentionally approaches within 25 feet of a law enforcement officer lawfully engaged in the execution of the law enforcement officer's duties after the law enforcement officer has ordered the person to stop approaching commits unlawful encroachment on an investigation, a Class C misdemeanor, period. And notice the word approaching is in italics twice. I emphasize it because of that. This court wants to point out that the word approach and approaching is what's the key to the statute. A form of the verb approach triggers the buffer law twice over. Then they actually cite the Oxford English Dictionary. These wonderful books here and over there. According to OED, approach means to come nearer to or to draw nearer to in space. That is, motion towards something is approach. If you stop, you are no longer approaching. That is extremely important. First, an officer must invoke the law by ordering someone to stop approaching. Someone who is not approaching in the first place cannot logically be ordered to stop approaching. So if you're standing there and an officer says, excuse me, stop approaching. I'm not. I've stopped. That's it. Second, once told to stop approaching, only someone who nevertheless knowingly or intentionally approaches within 25 feet of the officer violates the buffer law and risks being convicted of a Class C misdemeanor. That is what the buffer law does say. What the law does not say is that an officer may use the buffer law to order a person to move away to a point that is 25 feet or more from the officer. As the district court noted, the buffer law criminalizes a person's knowing encroachment into an officer's zone of integrity after the officer has advised the person to stop approaching. The buffer law is not a force field. That's what they say right here. So what they're getting at is you're walking up towards a police officer. He goes, excuse me, stop. You stop. You have now complied with the law. He cannot say, well, you're within 25 feet of me. Back up. No, the law doesn't say that. The law doesn't say that. Now, don't get me wrong. Police will probably misinterpret this for a while and arrest a bunch of people who don't back up. But guess who's going to win that fight? So, again, the buffer law is not a force field. Nor does the law say anything about video recording. If ordered to stop approaching, one does not violate the buffer law by stopping one's advance, staying put, and if recording, continuing to record. So this court is specifically, explicitly, clearly stating that if they tell you to stop and you stop, you are complying with the law. One does not violate the law by stopping one's advance, staying put, and if recording, continuing to record. That's it. That's it. And so the court then goes through many, many pages discussing how this is and could be construed as a First Amendment case. But of course, it doesn't actually address content of anything being recorded. So it's considered to be content neutral. So that's generally not a problem because of the way that the statute is written. It then also discusses a couple cases that the plaintiff had pointed to and said, hey, I think these cases apply. And the court says, no, they don't really apply for any of those purposes. The court is saying that the Indiana buffer law will withstand constitutional scrutiny with respect to the First Amendment. So there's 24 pages here going into that. If you really want to read it, all the cases called Nicodemus versus the city of South Bend, Indiana. It is out of the 7th Circuit, and it's very, very easy to find. It was decided just a couple days ago. But the key here is that apparently everyone kind of misunderstood what the law said. And I had not studied this particular law because a bunch of different states have passed these now. But if the law says that a police officer can tell you to stop approaching, well, you stop approaching. Law does not say he can then back you up. Does not say that. Now, there might be something else in the law that allows that. So, for instance, I'm hypothetical here. Hypothetical. Let's suppose that there's a police officer who's pulled a car over. He walks up to the driver's side window while talking to the driver, does not notice that you've walked up with a camera and are literally this far. You're holding it like right here, right by his head. And he turns around, there's a camera right there. Okay. I'm pretty certain the police officer can say, excuse me, back up. Get away from me because I'm worried about my safety now that you're within inches of my head with your camera, okay? Hypothetical. I'm making up facts to prove a point. He can't tell you to back up based under the buffer law because the buffer law says he can tell you to stop approaching. And he tells you to stop approaching and you got the camera right here. Well, guess what? You can say, I'm not approaching anymore. I'm not moving. But the point is what the buffer law says. The buffer law says that he can tell you to stop approaching once you're within 25 feet of him. And once he tells you to stop approaching, you've got to stop approaching. And if you continue approaching, which means moving closer to him, well, then you're violating the law. And I know a lot of people are going to say, but Steve, if he comes towards you, aren't you still? No. He's approaching you. Not you're approaching him. And so the court's pointing out that the word approach is used two different ways. I think it's approaches and approaching. But that's the key word here. And it means that the person that the law is addressing is coming closer to the police officer. Police officers got the right to tell the person to stop approaching. And if they stop approaching, they are following and within the law. Now, will a police officer not get the memo on this and tell someone you've got to back up because the buffer law says you got to back up? I'm sure it'll happen. Will a police officer arrest somebody who said you didn't back up when I told you to back up? Possibly. And who will win that when it goes to court? The person who wasn't approaching will win because they're going to say the statute says that I must be approaching and continue approaching when within 25 feet after being told not to approach any further. And I stopped. I wasn't approaching any further. And then if you're in the 7th Circuit, you hold this up and you go, right there, Your Honor. Right there. Right there. And straightforward. Again, like I said, there will probably be some confusion. But here's the thing. I wouldn't be surprised if the Indiana legislature now rushes back into the legislative session, figuratively speaking, to modify this. Because there could still be a problem where somebody gets really, really close to a police officer and the officer, for whatever reason, hasn't told them to stop approaching. And again, in a hypothetical situation, let's suppose that there's a police officer talking to somebody and somebody approaches from behind them and literally gets right behind them. And the police officer turns around because they sent something and there's literally somebody nose to nose with them, I'm pretty sure the officer can tell that person to back up. They just can't tell them that if they don't back up, they're violating this law. This law specifically says they've got one ability, and that ability is to tell someone to stop approaching. And once they stop approaching, if they don't approach any further, they haven't broken the law. So again, the court says pretty much everyone kind of missed this, but there you go. And of course, this could still be appealed to the U.S. Supreme Court. But I suspect what's going to happen is the legislature in Indiana is going to try to add something in there to indicate that if somebody has approached within a certain distance without being told not to approach, simply because the officer missed it or was busy doing something else or whatever, there you go. So again, the case is called Nicodemus versus City of South Bend, Indiana, and the state of Indiana, decided recently out of the 7th Circuit Court of Appeals. And it was sent to me, by the way, by a person who uses the initial B, the initial B. Thank you very much. Questions or comments, put them below. Otherwise, talk to you later. Bye-bye. And by the way, I'm going to tack this on. I didn't mean to rush through this video as a subconscious thing, but I originally shot this video about an hour ago, and I shot the video involving a 24-page opinion. I prefaced it by saying this video is going to run long, for which I now apologize. And when I was done shooting it, I got up to get behind the camera and to shut the recording off, and the recording had already shut itself off. And it shut itself off about 5 minutes earlier. Apparently, the camera got bored. It was a technical issue. I've determined that the card was bad, the digital recording card. So there you go. I'll talk to you later.
Thank you for watching Lehto's Law. The facts, although interesting, are irrelevant.